Good afternoon, everyone. Hi, I am Aubrey R. Cervantes from Group 2. I'm here today to talk about intellectual property. But before that, I will introduce my group mates, Genevieve Samar, Jack Nava de la Cruz, Princess Rhea Camacho, May Lumabi, and Aaron Ramirez.
Intellectual property is a category of property that include intangible creation of the human intellect. There are many types of intellectual property and some countries recognize more than others. The best known types are copyrights, patents, trademarks, and trade secrets.
Copyright is a type of intellectual property that gives its owner the exclusive right to copy, distribute, adapt, display, and perform a creative work, usually for a limited time. Creative work may be in literary, artistic, educationally, or music form. Copyright is intended to protect the original expression of an idea in form of creative work, but in the idea itself. Copyright is subject to limited based on public interest considerations such as the fair to use doctrine in United States. Some jurisdictions require fixing copyrighted works in tangible form. It is used often among multiple authors, each of whom holds a set rights to use license the work, and who are commonly referred to as rights holders.
A patent is a type of intellectual property that gives its owner the legal right to exclude other from making, using, or selling an invention for a limited period of time in exchange for publishing and enabling disclosure of the invention. In most countries, patent rights fall under private law and the patent holder must sue someone infringing the patent in order to enforce the rights. In some industries, patents are an essential form of competitive advantage. In others, they are irrelevant. The procedure of granting patents requirements placed on the patentee, and the extent of the exclusive rights vary widely between countries according to national laws and international agreements. Typically, however, a patent application must include one or more claims that define the scope of protection that is being sought. A patent may include many claims, each of which defines a specific property right.
A trademark is a type of intellectual property consisting of a recognizable designs, signs, or expressions that identifies product or services from a particular source and distinguishes them from others. The trademark owner can be an individual, business organizations, or any legal entity. A trademark may be located on a package, a label, a voucher, or on the product itself. Trademark is used to identify services are sometimes called service mark.
The first legislative act concerning trademark was passed in 1266 under the reign of Henry III, requiring all bakers to use a distinctive mark for the bread they sold. The first modern trademark laws emerged in the late 19th century in France. The first comprehensive trademark system in the world passed into law in 1857. The Trademarks Act 1938 of the United Kingdom changed the system, permitting registration based on intent to use, creating an examination-based process, and creating an application publication system. The 1938 Act, which served as a model for similar legislation elsewhere, contained other novel concepts, such as associated trademark, a consent to use the system, a defensive mark system, and non-claiming right system.
Domain names. Domain names is a string that identifies a realm of administrative autonomy, authority, or the control within the Internet. Domain names are used in the various networking contexts and for a network domain or an Internet protocol resources. In general, a domain name identifies a network domain or an Internet protocol, such as a personal computer used to access the Internet or a server computer. Domain names are often used to identify services provided through the internet, such as a website and email services. As of 2017, 330.6 million domains had been registered. Domain names are formed by the rules and producers of the domain name system. Any name registered in the DNS is a domain name. Domain names are organized in subordinate levels of the root domain, which is the nameless. The first level set of the domain names are the top level domains, including the generic top level domains, such as the provident domains com, info, net, edu, and org, and the country code top level domains. Below, these top levels domains in the DNS hierarchy are the second level and the third level domains that are typically open for the reservation by the end users who wish to connect local area network to internet create other publicity accessible internet resources of run website. That is the domain names.